Hey everyone, sorry that I forgot to turn the sound on and we did our entire intro without you guys here.
Hello, welcome to Winning Wednesdays now with the sound on for sure.
It's okay because now we can just do it better.
That's exactly right.
Today we're here to discuss drug-based DUI. A pretty weird topic.
A really weird topic because as we were saying a while ago, a lot of people don't know that drug-based DUIs even exist, right, Brandon?
Right.
So let's start this topic. Today with me, as you guys know, is Brandon Cott, one of the attorneys at Adair Thurston, and we're going to talk about drug-based DUI. So, Brandon, what is a drug-based DUI?
So, a drug-based DUI is really different from an alcohol DUI in one main respect.
Okay.
Alcohol DUIs, we have per se limits. We have that whole number thing, 0.08 here in the state of Kansas.
Right.
And that's pretty uniform throughout most states. But in drug DUIs, we're not going to have that. We're going to have some other value of testing in order to prove that kind of case.
Okay, it makes sense because you don't have necessarily the ability to use the little PBT test to say, oh, this is how much they are intoxicated by.
Exactly.
Correct?
There's no such thing as like a marijuana PBT right now. I mean, I'm sure that those things are in the works.
They will come. I'm sure they will come.
Law enforcement catches up as soon as they possibly can.
Absolutely.
But yes, so for right now, that's the main functional difference is that it's going to actually be a qualitative kind of proof, right?
Okay.
That you were incapable of safely operating because you were under the influence of a drug.
Okay. And so obviously the legal standards are different, and one of the ways you said that you don't have this hardline 0.08 thresholds like you do with DUI, with alcohol-based DUI. What are other ways in which a drug-based DUI differs from an alcohol-based DUI?
So in a couple main respects, right, it's going to be the testing type, the things that are done during this, potentially having to get a search warrant because of those tests.
Oh, okay.
There's also the potential of differences in the administrative sides of the case.
Okay.
If you think back to when we talked about DUIs and kind of administrative stuff, maybe a few videos ago.
The DL hearings is where you're talking about. Okay.
Right. So that's going to be functionally different as well.
Okay.
So if it walks like a DUI and quacks like a DUI, it probably is, but it's going to look and quack a little bit differently than all the others, right?
Okay. So given those brush strokes that, like you said, that differences being in the testing, being in the civil side, the DL hearings, that type of stuff. Let's start breaking it down into smaller bite-sized pieces, if you don't mind.
Right.
Let's start off with normally the way a DUI starts is because you are operating a vehicle, right? And you are, and something that you do potentially causes the police officer, so to speak, to initiate a stop in a interaction, right?
Right.
So how is that different in a DUI, alcohol-based versus DUI, drug-based?
Well, the main difference here after, making contact with a driver, I mean, when we're on the ground, the main difference is going to be the type of tests that ensue. An officer is going to come to the window, driver's license and registration, right? So
same as a regular DUI, stopping. Do you know why I pulled you over? Can I see your driver's license? Can I see your insurance? Okay.
Whole same, right? Okay. The big difference I find in my cases is really going to be what happens when they get to the window, right? What do they smell? Do they smell marijuana? Do they smell alcohol? Right?
Okay.
And I will tell you, by far, marijuana DUIs are the most prevalent that I've dealt with. There are also prescription drug DUIs, and we'll talk about that a little bit. But for the most part, right, like that's where an officer is going to really hone in on a DUI. I smell alcohol. I smell marijuana, right?
Okay.
Now, if we smell marijuana and we've got a person behind the wheel, we know that we have the potential for a drug DUI, right?
Okay.
But the tests that we're going to do upon making contact with that driver are going to be different because, we're not going to do the same standard tests, battery of tests that we would for an alcohol DUI. There are some tests that will play both roles.
Okay.
But, in terms of roadside analysis for a drug DUI, there's an officer with a special qualification called a drug recognition expert.
Okay. And so basically your regular beat cop is going to, if they believe that there is some incapacitated or unsafe operation of a vehicle, will then bring in this officer to start then the testing process.
Right. And not every department has these DREs, drug recognition experts.
Okay.
You actually have to go to a special training. Tom and John have been to the special training,
Okay.
of course.
Of course.
So the fact is this training kind of teaches you how to detect indicators that might be present in somebody who has impairments that are not related to alcohol. Okay. Right? Because even to the extent you can get a DUI while drinking and being under the influence of drugs, right? I went to a party, smoked a little weed, drank a little booze, now I'm driving, right? Not necessarily the best idea that we've ever had, but the fact of the matter is we can still even get a DUI for the combination of the two.
Oh, okay.
So the real issue for them is going to be how do they prove up their case? And that drug recognition expert, they're going to be the ones to help them do it.
Okay.
Right?
Okay. So that's so even from the onset at the stop, the beginning of the police interaction, there's going to be differences that you will have to basically review in order to determine how it works and how to best defend your case.
Oh,
your client
absolutely.
in this case.
Oh my gosh. DUIs are like snowflakes. They are incredibly fact driven, and every single one is different because.
What a wonderful analysis.
Yes. Whenever you're thinking of probable cause, probable cause is so dependent upon the facts of that specific case, the smells, the sounds, the sights, the infractions. And you can have any one permutation of all of those facts.
Right.
And so that's where the litigation comes into play. That's like where my love child is, right?
Okay.
So that's why it's really important for us to have this level of training and recognition of these things, because the fact of the matter is, in litigation, if you don't understand the material, you're not prepared for class. Right. You know what I mean?
Absolutely. Absolutely. So let me ask you a question. You indicate that these... even the initial stops with the police have to have some differences. So, question: is there if you refuse to perform any of the tests, sobriety tests that are either being used that are more alcohol based, or even the ones that are drug based, do you have problems as a result of refusals?
Well, that's actually a really mixed answer right now that's being litigated in the Kansas courts.
Okay.
The way that standard field sobriety tests are described are voluntary. These are voluntary tests, right?
Right.
And voluntary also comes with a connotation that if I don't do it, it's not going to be held against me, right?
Correct.
If it's voluntary for me to go to that party, you're not going to quit being my friend if I don't, right?
Right.
If it's mandatory or compulsory, okay, fine, right? Now I know what the limits are.
Right.
But there has been litigation in the appellate courts as to whether or not a judge is allowed to hold the fact that you did not participate against you.
Oh, okay.
So, that is really a personal choice. But the one thing I always tell people about standard field sobriety tests is like, these tests are not designed for you to succeed. Right. You're not somebody who's trained in administering these tests or taking these tests, or somebody who looks at these tests on a regular basis every day. So
you may
it's
not
hard.
have the physical capacity to complete these tests.
Right.
Something as simple as excess weight, I am assuming, can impact the quality of your ability to perform these tests. Right.
And these are physical tests, and then there are also the mental tests.
Right.
The fact of the matter is that these tests are described as voluntary, and frankly,
by and large, I mean, I know you indicated there's the litigation going on, and once the litigation clarifies, then we know. But in the meantime, what is your observation of the current judges, at least that you dealing with this? Do they see voluntary and say, well, come on, you guys, the person is being told it's voluntary? Or do you see more of the other aspect that it's voluntary but not really?
That is so judge-based, right? I mean, each individual has their own ticks about that.
Of course.
But the fact of the matter is, whenever describing performing standard field sobriety tests to somebody, in a case, people can get evidence against you. And there are certain acts that we do that allow the pile of evidence against us to build up higher and higher and higher. And my job as a criminal defense attorney is generally to make sure that pile stays as small as possible, right? And now if you're engaging in standard field sobriety tests that have multiple opportunities to fail, you're a novice at this unless you've been practicing at home. You're very, very surely not going to remember all of the instructions because they're numerous, right? Your opportunities to fail here are pretty high. Your opportunities to succeed, very low. So as somebody who makes strategic decisions, I would say never allow them to collect more evidence against you in this situation
than is necessary.
Right.
Gotcha.
I mean, because the fact that unless you are going to just kill those tests, right, which I can count maybe on two hands the amount of times that I have had an officer admit that somebody passed the test, right?
Gotcha.
Out of all of the cases. So
wow.
The fact is, it doesn't happen very often. So you're very much better off not giving them more evidence against you.
Okay.
Right?
Okay. So in the refusal question, it's still pending litigation. Some argue that it's better to not do them. Some argue that you should, because even though they say voluntary, some judges don't really see them as voluntary. So we'll see what that litigation comes out with, right?
And I'm super interested as well, because this really will determine the pace of these cases for a really long time, because this is really the foundation of what officers use when conducting.
Absolutely.
So
absolutely.
Yeah.
So you
sorry I got off topic.
No, but that's a great thing, and actually it leads to my next question for you, which was, how is evidence obtained in drug-based DUIs, and how should we be trying to protect ourselves if we are being accused of such a crime? With respect to evidence.
Yeah, perfect question, because like we said, it's going to have some similarities to an alcohol-based DUI, but then it's also going to have some differences. Primarily in a drug-based DUI, right? We're at the window, we smell marijuana. There's a possibility. So number one, if we smell marijuana in a car, one of the Carroll doctrine tells us that we get to search that car, right? It's a movable object. And in Kansas, at least, marijuana is strictly illegal, right? There's no legal way to possess it.
Right.
So we know that illegal activity is going on. We get to search the car.
So just the saying, by George, I believe I smell marijuana.
That's the way.
That's enough for them to get into your car.
Correct, right? But if we're also going to be looking at a DUI, right, we need to be conducting tests during that time. And these tests are frankly the best way that officers are going to be getting evidence against you on a drug DUI, at least in the beginning, right? Because that's how they're going to try and get through probable cause. The DRE might potentially be there, more likely going to be at the station. The chance of getting a certified officer at that stop at that time, rare. Right?
Gotcha.
And then going back to the station, right? Well, in an alcohol-based DUI, we'd be getting a breath test done, right? Or
the more sophisticated version of
the Intox 9000, right? Okay. And so then, if we're drug-based DUI, breath has no meaning to us, right? So we're going to want a blood test.
Right.
And how are we going to do that? Get them to a hospital.
Okay.
Right.
And is there any responsibilities that law enforcement have when trying to secure that blood test, that type of physical evidence from your body?
Yes.
What responsibilities do they have?
So actually, in order for the blood test to be entered as evidence at all, they have to meet foundational requirements in order for it to be considered competent evidence, right? Because you can't just get some crap blood test and not do any preserving, right? This is an evidential blood test. This is not just a hospital blood test, right? Okay. So the tubes need to make sure that they're not expired. There's all kinds of issues there. Make sure that a medical professional is the one conducting these tests, right? We're not just going to let some police officer stick a needle in anybody's arm, right?
Gotcha.
There are some officers who are permitted to do that.
Are they trained? They're trained and
certified?
certified?
Yes. So bat cops, the ones who are able to take blood at the scene, right? Those are the ones who they're going to put you down on a car hood and do a blood draw right there, right?
Okay.
So not a hospital. But for the most part, even when we're talking about the blood tests, we're also concerned about warrants. Because we don't just immediately get a blood test.
Okay.
Schmerber versus California, actually a whole progeny of cases that come from that tell us that blood tests are different. That's an intrusion into our body, much different than the air that we exhale.
Exhale, right? Because we're exhaling all the time is the argument, right? I'm assuming. Okay.
And if you ever find yourself in a position where an officer is seeking to make an intrusion into your body in order to do a blood test, I always tell people, do not stand in their way. You are not going to obstruct, right? But please make your intent known. Officer, if you need to get a warrant, I would like you to get a warrant. I don't know if you need a warrant at this point, but if you need a warrant, I need you to get one, right?
Okay. I see what you're saying.
And if they don't think they need a warrant, if they think they're just going to go and take your blood,
then don't argue with them. You can't.
Then you let them make the mistake.
Argument. Right. You're not going to win the argument, but at least you've voiced the intent. Okay.
Exactly.
So I have. Thank you, Paul Duran, great friend, for asking a really great question. What are the penalties for refusal in Kansas? So I'm assuming maybe refusal to take the test, refusal for PBTs, and since he didn't ask, I'm going to say give us both an idea of alcohol and drug related and what the differences are, if you don't mind.
Absolutely. So drug-based is going to be like a refusal of a blood test, right? Mm-hmm. But in terms of Kansas, so what are the penalties for refusal in Kansas? So those are going to be mostly breath test related or refusal related. There is not a criminal penalty for refusing a breath test in the state of Kansas. That was actually the subject of litigation, hot litigation, maybe like a year or 2 years ago.
Okay.
And
so no penalty for refusing breath tests?
Right. So they cannot make a criminal implied consent. Now the court has given them a back door to do a workaround there, but the state legislature still hasn't elected to do that.
Okay.
So the fact of the matter is there right now is not a criminal sanction on the book for refusing. Now, where we get into the deep sticks is the state is aware that they do not have any power to criminally prosecute for refusing. So what do? They ratchet it up on the administrative side, right?
Oh, okay.
In each instance, first, second, third, fourth, or subsequent offense, the general rule is that if you refuse, the suspension that tacks on at the end, or the interlock period that tacks on the end, add a year to it.
Okay, so once you've either gotten through a plea or a conviction, if you refuse,
right?
Then if the court says your penalty is 1 year with an interlock device.
And remember, this is an administrative agency.
The administrative agency says no, add another one. It's 2.
No, yeah.
Oh, okay. So or what? I'm not.
Yeah, so that administrative penalty will already be ratcheted up for the refusal. Now, the DUI side, yeah, you can still get convicted of the DUI, but over on this side, where the administrative refusal is being processed, that's where it's going to get ratcheted up if they find the.
But is it the probation period that it gets extended, or the length of time that you go without a license?
It is the length of time that you will be required to have an interlock in your vehicle after your suspension.
Oh, okay, I understand. Yeah. So even after you've paid your debt to society, you have additional debt of more time with an interlock device.
Right. Okay. And again, right, these are creatures of the administrative world, so they don't actually count as criminal punishments, because otherwise we would be walking into court arguing double jeopardy all day long, right? The state of Kansas is a lot of things, but clever is surely one of them, right? They know how to get their pound of flesh, and so that's really what that is. And also for that hardship license, refusals will have an additional waiting period. It goes from 45 days to 90 days before you can request that hardship license.
Okay.
So I hope that that's
clear, I mean, I think it's very clear in itself, but what is a hardship license?
basically a hardship license is where after the first period of suspension on a DUI case, so if you're suspended for a year, then after 45 days, you petition the state for a hardship license that allows you to drive to and from school, to and from work, or in the case of emergency, with an ignition interlock device.
Oh, okay.
But, right, so we're restricted, plus we have the ignition interlock. Then, once we cross over, we just have the ignition interlock, and we can drive wherever the hell we want to.
But the interlock device is
Yep,
still in
and
there.
it's there for longer because we refused.
Gotcha. Okay.
Right.
Okay.
So I hope that answers the question.
That's-
That was very detailed. So
Well, it was a
hope.
complex question.
Yeah,
truly.
administrative suspensions are literally the calculus of DUI law. That is where people get into the most trouble, frankly, and that's most of the time why I'm telling people make sure you're talking to an attorney, because the criminal side of the case is really going to be managed by the system for the most part. But on the administrative side, there's nobody there who cares about holding your hand
and helping you get your license
yeah
back.
and frankly it's easier for them to just suspend you, so like why would they help?
Right.
And there are lovely people at the Department of Revenue. It's just
Right.
you're not their first concern
Not
usually.
a criticism of
Right.
them as individuals, but more as an agency. They're not going to
they're not going to
they're not
request
going to
that.
they're not going to walk you through the steps to help you get back to the point where you're driving legally.
Exactly.
Okay, that's
Yeah.
a fair analysis. Paul had yet another question, another great question.
Yes.
If your vehicle is an extension of your home, do you have to interact with police through an open window?
So like if this is a trailer home?
Well, no, I'm assuming he's assuming that you have as many rights to not consent to converse with law enforcement in your vehicle as you do a house.
Right.
I'm assuming that's at least that's how I'm reading it.
Oh, well, I was going to say if a law enforcement officer comes to your door, they'll make it pretty clear to you whether or not that's going to be mandatory, right? You're always free to not initiate contact with officers.
Right. Well, but I think in his position, if a law enforcement officer does initiate a traffic stop, how much communication? How much does he have to give?
Identify
the law enforcement
yourself.
Officer, does he have to actually roll down the entire window? Can he just crack it open, give the documents, and then be like, I've given you what you needed, and
Crack the window, driver's license, insurance. That's it. Officer wants to ask questions. Officer, I'm not discussing my evening. Thank you. Can you tell me what I did wrong? Am I free to leave? Right? These are really great questions. They should answer those questions for you. If you're free to leave, they should tell you, and you should take that opportunity.
right.
Yeah, so.
Oh, absolutely. Well, and I think that I know Paul's a very law-abiding person, but
surely,
some
yeah.
other people might think, well, if me rolling down my window means that I'm already starting to give them evidence by whatever sensor wafting through my window, well, how can I limit the amount of evidence I give them, as you said, right?
Well, the fact of the matter is, not rolling down your window, that's going to be kind of a weird situation in the beginning, right? I would say, the fact of the matter is, if those fumes are going to be moving out.
So it might, opening it up just a crack might be another reason why the officer says, oh, probable cause.
Exactly. Oh, yeah. I mean, if that officer smells marijuana, you're going to be out of that car and it is getting searched.
Or even just saying that they smell marijuana and the reason that the window was open so tightly, maybe?
Yes.
Maybe food for thought? Okay.
Yes.
So now you talked about the administrative ramification, or talked a little bit about administrative procedures. Are there administrative ramifications that are different in drug-based DUIs than in alcohol-based DUIs?
Actually, a lot of people are surprised when they get a drug-based DUI, because a lot of the times that we spend on DUI topics, we spend talking about administrative side and suspensions, and those are like the really scary parts.
Right.
But
not being able to drive to work to feed your family is a big scare for a lot of people.
That would frighten me.
Absolutely.
So the fact of the matter is, a lot of people who get charged with DUI drug cases are really surprised when their licenses come back in the mail to them, for the very simple reason that in some respects, it's illegal. It's a violation to refuse that test, right? We get punished for that, and it's a violation to be over a .08. Right? But we don't have the same corresponding statutes on drug-based DUI cases, right?
Gotcha. So the administrative side doesn't have the case law built up to be able to do the same punishment?
Well, the fact is as an administrative agency, they're a creature of statute, and that is not a part of the administrative statute. Now, you could be convicted of that DUI, and that could initiate a suspension, right? We know that will work. But through the administrative process, it will not happen. So, is there still that potential? Yes, but it is lessened significantly there. Right.
And in that case, then maybe the end result of your license being suspended is not from a separate administrative proceeding, but because criminally, if you are convicted of a DUI, you do have some suspension period?
Correct, yes. Okay. So you will be, they have the chance at 2 points, either in the administrative case or by convicting you in the criminal case.
Oh, okay.
So if they get the conviction in the criminal case, right? But if this is a first offense, drug case,
consider diversion,
right? Then if we get a diversion, look, now we've got something that's manageable, right? Something that's not necessarily a deal breaker. So there's a lot of workable alternatives, but again, right? Like talking to an attorney who is playing chess with these ideas, because there are ways of working things out to benefit somebody, or at least to help them take less impact.
Lessening the damages of conduct is what we do as lawyers, for sure. So now, a question for you. I mean, we're talking drug-based DUIs.
Right.
What if the drug is something that was prescribed to me by a doctor? Can I simply go to the prosecutor and say, hey, I got a prescription for that. It's all good.
I wish. Handing the prosecutor the prescription might just make it easier for them to identify what it was, right?
So
giving them evidence.
What you can do to negotiate for yourself may not be what a lawyer can do to negotiate.
Exactly.
Okay, so let's talk about that then.
Yeah. In terms of these cases, right? For instance, like in our office, we spend so much time educating with prosecutors, because the classes that teach these kinds of methods are offered pretty exclusively, and they can be kind of expensive, and the state doesn't send a lot of their prosecutors to go and do these classes, right?
To understand the actual breakdown of the drugs and that kind of stuff.
Of drug blood testing and drug analysis. So a lot of times we sit with prosecutors and we talk about the fallibility of these tests, and we say, you know what, call your experts, call the people over at the KBI, tell them that these are the questions you're going to ask them, because those are the questions I'm going to ask them. And they're going to have some problems answering them, right?
Gotcha.
A lot of people think, if there's a blood test, I'm just screwed, right?
Right.
That is absolutely not the case, and absolutely not the case with these kinds of issues. Because, for instance, right, you take your prescribed medication, and you're within your therapeutic level. I mean, every medication we take intoxicates us to some degree, right? It's being introduced into our body to give us a certain effect.
Right.
So if you are within your therapeutic level of intoxication while taking that, surely the state isn't there to try and say, this doctor is handing out DUI pills, right?
Right.
So that being said, I think that's one of the main.
Okay, gotcha. So now you've talked a little bit about, of course, some of the things that are contemplated, some of the defenses. Is there, and I probably know the answer to this, but is there any quick and easy defenses that a DIYer could try to employ in this case? Or is it really, because of the heavy science of drugs, of the drug breakdown, the impact on the bodies, this is the type of case that you really should have a qualified lawyer for?
yes, you should have a qualified lawyer. Because actually, the exact opposite is true here. If you try and do the quick and easy, you're probably going to harm yourself.
Okay.
And the reason being is because, right, I told you, when most people look at that blood test, they think, oh, I'm screwed, right? In the same respect, when the prosecutors got that blood test in their hand, they think, I've got the best evidence in the world. I'm going to win, right? And sometimes you have to go and explain why exactly that is not the best evidence in the world, right? So, me sitting here on a video saying, oh yeah, blood evidence, we need to look into that. There are some questionable things happening there. That's a lot different than you picking up the phone and doing it, right?
Absolutely.
Both of the people who taught me everything I know are forensic lawyer scientists, meaning that they went out and got a distinction with the American Chemical Society to be forensic lawyer scientists.
Well, and that actually brings me to my final question. I mean, these types of cases do sound pretty complex, right?
Yes.
What have lawyers in our law firm done? I mean, and you already started touching upon this, some special distinctions, some special training to be identified as forensics lawyers. They've taken tests to confirm that they meet the certification requirements. What are some of the questions people should be asking their lawyers to make sure that they have this kind of knowledge?
Have you ever, litigated a drug-based DUI before? Have you taken it to trial? Have you, what kind of reports do you look at? What do you get from the state? Right. Do you know this prosecutor? These basic questions, but also, start asking them about their qualifications in regard to
what is your
case.
Education and training to understand drug composition? What is your education and training to understand maybe how the law enforcement identifies, right? I mean, you had talked about the guys having some drug...
yes, DRE experts.
DRE experts.
Yeah.
Meaning you can recognize drugs and the impact on a person, right?
Exactly.
Okay.
So they've been through that training, the same as the officers, right? So we have a foundation for us then to ask the question as to why didn't you do it this way? Why didn't you do it the better way that your manual tells you about, right? A lawyer who's never been through this training, a lawyer who's never had contact with these kinds of cases, maybe doesn't know what questions to ask or the appropriate questions to ask, right?
And that's always the biggest downside, is not knowing the right questions to ask, right? In any legal case, the difference between either doing it yourself or hiring a lawyer or hiring a general practitioner versus someone who's a more concentrated attorney comes down to the experiences, the work background, the trainings, the certifications that you've tried to help bring your experience to the next level.
Yeah, it absolutely does. And frankly, like I always tell people, I stand on the shoulders of giants. I will probably never have as many awards on my wall as Tom and John do. But the fact of the matter is, they're always an amazing resource to speak to about any of these cases. Even I, who have dealt with these cases, I still go up to them and talk to them about them, each one of us, whenever we have one, because you know what? They can be complicated, and it helps to have a team approach and to look at it from different angles. And I guess that's one of the real saving graces of being here and doing this practice. So I'm very thankful.
Well, we're so excited that we were able to talk today about drug-based DUIs with Brandon Cott, my colleague. If you are interested in learning more about drug-based DUIs, if you are in the process of having to deal with a drug-based DUI, don't let the fear and anxiety get the best of you. Contact us. Let us know how we can help you. We are here for you. Dare Thurston is available at 785-776-2000.
And do not, if you love Winning Wednesday and you love our programming and seeing us, and if we can offer anything else, drop us suggestions, leave us comments, like, share, and subscribe. Please. Get the word out about Winning Wednesday. You would be doing us a huge favor, and we would appreciate that so much.
Absolutely. And you'd probably be doing your friends a huge favor, because sometimes a little bit of information is what helps us take the next step in our lives. Be it we have a criminal situation that we need to address, or we have a situation where we are in love and we want to bring the love of our lives from a different country into this country.
Right.
Which coincidentally is the topic for next week.
Woo!
Fiance visas.
Oh, yay.
2 days before Thanksgiving. Oh my gosh.
I wish.
Before Valentine's Day, I had to do it.
It's
Fiance
perfect.
visas. I'm very excited to talk about this next Wednesday.
Love is in the air for next Winning Wednesday, so we're excited to see you all
Yes,
there.
we are.
And send us candy.
Lots
Yes.
of candy.
Thank you guys.
Thank you guys so much. We appreciate you.
Have a good evening.